Okay, everybody, we are going to kick off for the evening. So thank you so much for being here on a very dark, bit gloomy day in December. It's nice to see so many people in the room. Thank you so much. If you are new, my name's Riley. I'm part of the committee. I'm also a dispute resolution lawyer at Macfarlane's. So nice to meet you if you're new. Thank you for our old timers and faces that are familiar for joining us again for our December knowledge session on climate activism in the UK. We're also very grateful to LSE's Grantham Research Institute for hosting us again and for our final knowledge session of the year. Thank you, Grantham. Just hi, welcome, find a seat where you can. Just to start us off very briefly with a few housekeeping points, and apologies if you've heard this before, but it's always good to have a reminder. If you need to go to the bathroom, the toilet are left out of this room. If you need some water, there's also a water point as well. If you take any glasses, please wash them up at the end. If you hear the fire alarm, it's not a drill, it's real. Keep calm, please leave your bags and follow us out of the room because we know where the fire exits are. The session is being recorded, the whole session, and you may see a couple of the committee members taking photos throughout the evening. If you don't want to be photographed, that's absolutely fine. Just come and tap me or one of the other committee members, Marina, who's just downstairs, on the shoulder, or Emily, who's just walking down the aisle very conveniently right now, and just let us know. We have our fantastic online audience as well as our wonderful in-person audience. Online attendees, please make sure that you're muted throughout just to avoid any disruption. And we'll be running a Slido, which I think you may have seen very briefly earlier. If you'd like to submit a question through Slido, please do. But also we're very happy to take questions in the chat box online or the old-fashioned way, put your hand up in the room. And as usual, we'll be heading out for a few drinks to celebrate our last knowledge session of the year, a busy year for Legal Voices for the Future. So if you'd like to join us afterwards for a drink or just for a chat, please do. It's always nice to get to chat to everyone after these sessions. And just quickly about LVF, if you're new to us this evening, we are an organisation run by and for junior legal professionals. We aim to bring junior lawyers from across the spectrum of, oh, thank you, Carol. It hasn't moved, but okay. We like to bring lawyers from across the spectrum, so junior barristers, solicitors, trainees and students together to learn and discuss the legal issues relating to the climate and ecological crises that are affecting the world at the moment. And the main way we do that is by hosting these monthly knowledge sessions on a variety of different topics, but we also host community events as well, so we get together as members. So if you'd like to sign up as a member, if you're not already one, it's free to do so. Please join us. You can also get access to our monthly newsletter. If you'd like to write for our blog, please do. We're always looking for blog submissions and knowledge sessions like this. And you can also access our previous knowledge sessions on our YouTube channel. And this one will also be uploaded if you want to go back and listen to anything in 2026. And as I said, we're here hosted this evening by the GRI. Thank you so much, GRI, for hosting us. I know we've got some members of the GRI dotted around the room. And we have Carol, who's our wonderful co-host this evening, who also works with Emily at the Grantham Research Institute in their climate change and governance team. So if you want to talk to them, get to know them, please feel free to do so. They're very friendly. And you can also subscribe to the GRI's Climate Laws newsletter by scanning this code, which you have a very brief amount of time to do before I move the slides on. One final thing is we'd be really grateful if you could fill in our members survey. It's always really helpful for us at LVF to get to know how our members are feeling about, the offerings that we're putting forwards, our knowledge sessions and our community events, so that we can make sure that LVF is working for you. If that's what we're here to do. It would also really help because we're filling in an impact survey, and it would be great to have your feedback in that. It's all anonymous, of course, but it'd be really helpful for us from a funding perspective so that we can offer you more in the future. And that's it for me. So I'll hand over to our wonderful host this evening, Carol, who's in the room, Tanvi, who's online, and Orla, who is also going to be helping with our fantastic panel. Thank you.
Thanks, Freddie. Hi, everyone. I'm Carol. I work at Grantham on the Climate Laws database, and I recently did a master's in environmental law and policy at UCL. Tanvi, who is joining us online today, is working as a ESG and sustainability associate in New Delhi, India, and she recently did a master's in environmental law at Queen Mary University. She also published an article in the Cambridge Journal of Climate Research on the criminalization of environmental defenders. So this is her expertise right here. And Orla, who is also co-hosting, is like me, a stewardship committee member of LVF. She's a bar course student at the Inns of Court College of Advocacy at the moment, and also a legal researcher who's working on different areas of the law, including environmental law. So we're very excited to host today's session on climate activism in the UK. Today, we'll start off with a video from the documentary The Line We Crossed, and then we'll have breakout discussions. Then we'll have a short presentation, which Tanvi and I will do to introduce you to the topic, and then we'll follow up with a panel discussion with 4 panelists moderated by Orla. We'll introduce the panelists later on. So we'll watch a clip from The Line We Crossed. This is a documentary that records the experience of those at the front lines of climate resistance, and it traces the quiet unraveling of protest rights in the UK. The film challenges us to question what makes dissent effective and where the line of acceptability is. We got in touch with the director, Liz Smith, to procure this clip, and this clip also features one of our panelists, Clive Dolphin. So I'll show the clip right now.
I was literally in court at the point where Judge Sayani gave his ruling. I heard it in my own ears.
You're under arrest for the offence of contempt of court.
And I read it again, and I've come along, and I've done the thing that a High Court judge said you're allowed to do, and yet I've spent the day in the cells here at the court.
So Justice Sayani threw Trudy's case out. I know they're appealing, but given that he's thrown it out, this seems even more extraordinary that you've been arrested, no?
There were some people who were holding up signs which are the same as Trudy's sign, and there was one person holding up a blank sign. So apparently the blank sign is okay, but the Trudy sign for which there is a legal justification isn't okay, and the new signs which just say an honestly held belief, they aren't okay either.
The new signs are?
The jury deserve to hear the whole truth.
Wait, the whole truth, nothing but the truth, so help me.
Where it's from, yes. And we have bail conditions. We're not allowed anywhere near the court within a certain area around here.
Is that one of the people who's sitting down?
Yeah, you've been identified, someone very similar to you, who is wanted in connection with obstruction to key infrastructure such as the Public Order Act of 2023, and it took place at an airport.
You're telling me I'm on a wanted list?
Yes.
Are you not upset by the fact there's a wanted list of protesters in the UK?
Not really, mate. I'm a policeman.
Doesn't worry you? There's a list of people wanted for protest. If you're wandering the street at any point, you might get arrested.
There's an investigation into these things.
No one told me that.
Unfortunately, I'm telling you now.
House arrest, street arrest, people wandering the street now.
Yeah.
Getting picked up by police officers for thinking about protest. Is that the idea?
Well, I disagree. It's quite like that, but there is an investigation to be conducted. So as you
Sounds quite a
understand.
lot like that.
Well, I'm not going to argue with you. You seem like a nice lad.
the European Convention on Human Rights in Article 6 on the right to fair trial. One of the components is the right to present your defense, to decide whether or not you want to be represented, but also to explain to the jury the reasons why you have decided to do something, in fact. In the case of Daniel Shaw and other activists, they have decided to use civil disobedience, which for me respond to 4 criteria. The people know pretty well they are breaking the law. That means that they are ready to face a tribunal. It should be, second criteria, public. To break the law in public, to protest against sort of unjust law. It should be also done non-violently. And the clause of non-violence for me is very important. The International Covenant on Civil and Political Rights clearly says that the right to protest covers civil disobedience. The idea that a judge could decide all alone what is acceptable evidence to present to the jury is something which is, for me, difficult to understand. How a democracy would not be able to allow the defendant to present the evidence properly. And the fact that they are prevented in UK to do so is a matter of great concern for me.
So last time you and I were here, we thought you wouldn't be able to be outside Southwark Crown Court again. But here you are outside Southwark Crown Court. What happened in the end?
When the verdict came out, we initially heard that the charges against us had been dropped, and then we found out why they'd been dropped and the bizarre circumstances in which they had. Judge here decided that because Dr. Neil Stevenson, a retired GP, had hearing difficulties, that we as a group were vulnerable. He then went on to take it a step further and say, because we were vulnerable people, he believed that Roger Hallam had manipulated us into being outside of the court. We are not vulnerable people. We were not outside of the court because of Roger Hallam or anyone else.
We're here to show solidarity with Cressy and Daniel and Lucia and Lou and Roger. These are our friends, and to come to a sentencing off the back of that kind of trial is sickening, really, especially with the judge's comments right at the end of the trial saying that they should expect long, long sentences. I think it's incredibly dystopian, really.
We're now looking at a judge threatening them not months, but years in prison.
He's looking to set the bar higher than with Marcus Decker.
Yeah, it is emotional. Just not knowing how long they're going to be sentenced for. That's a difficult place to be in.
I waited outside in a London Crown Court for your van to come out 18 months ago. What does it feel like when you're inside it?
Oh, that's a mixture of things, but being aware of people who are outside that support you, that's a real boost to the soul. Just being in one of those little cubicles inside that van is an unpleasant physical experience in itself. So each of those little small windows will have a cell inside each one of those. So they're very small spaces. If the journey is any length, travel sickness starts to become an issue. So it's just not nice from beginning to end, really. But seeing people and feeling people shout and bang the van, that must bring a joy.
Can you hear them? Can you hear them?
Yes, you can. And I think they were playing a Clash number when I was driven out. The reality is they will probably get a very long sentence.
It could be like sort of 3 years.
Yeah. These people don't lie, thermometers don't lie. You know, they're telling it how it is, and the courts are deaf. Yeah.
Oh, universe. Can I turn your sign around? Not really. And then we've got our mates there, over there, photographing away. Oh, yeah. Where does it go from here?
We don't know at the moment.
But if you don't know, why are you arresting?
Because we're just waiting till we know where we're going.
Shame on you! Shame on you!
Arrested for conspiracy to interfere with critical national infrastructure.
I'll tell you what,
the sentences are getting worse, the repression's getting worse, the abducting of my friends on the street by the by the state is getting worse. And
tell me a bit more about that. What's been going on with these abductions?
Yeah, so quite a few of my friends have just been picked up by the police on the street, either going on their way home or having lunch with their mum. My house got raided, my housemate got arrested for the same charge as Dolly today. It's my new normal, basically. And, if I message a friend and my message is not getting delivered and I don't get a reply for 24 hours, I'm like, have they been arrested? Have they been raided? It's very uncomfortable.
Are you worried that you're going to get pounced on any minute?
I like to think that I'm not on their radar at the moment because I took a step back 6 months ago, so I feel quite okay showing my face here. But it's only a matter of time before they come for absolutely anyone. It seems quite random the way they've been selecting and arresting people. It feels like a weird mix of hopelessness and at the same time that urgency of like, well, it's now or never then. Like, we're the 1.5 degrees that we were still kind of hopeful about 2 years ago, that's completely gone. We're fucked. We're actually fucked. And like, well, if we're fucked, we've got nothing to lose, right? We've got everything to gain, so we got to go harder. I know some of the defendants as people. First of all, remanding them was horribly cruel. That was completely unnecessary. Taking away their last week of freedom where they could make their goodbyes and arrangements, taking that away is just so unfair and just, yeah, cruel. As for the sentencing, I'm still trying to come to terms with the fact that I'm not going to hug my friends for years to come, I'm hoping that they won't get that much more than Marcus and Morgan, but I'm sick and tired of the state taking my friends away and destroying their lives for the sake of profit, of business as usual. That just, I can't come to terms with that.
Right, we've got 5 years, let's got 4 years.
We're going to break out into groups to discuss the video and your reaction and response to the video with each other. Could I just get a show of hands, the facilitators in the room, please? Okay, and we don't have that many, so we might actually have to do, sorry, we had a...
Sure. Hello, everyone. I hope all of you can hear me. Thank you so much for being here. It's so nice to see everyone's face and see everyone online. Yeah, so essentially to set the scene before we get into the specifics about discussing the law, it's useful to look at what climate activism in the UK is looking like at the moment. And this really does underline everything that we just saw in the documentary. Over the last few years, we've seen rising levels of climate activism led by groups like Extinction Rebellion, XR, Just Stop Oil, Insulate Britain, and a number of other youth-led networks who essentially are demanding for greater environmental protection and climate justice. And the means and the ways in which that they are doing that has become more visible and more disruptive than before. So whether that's, blocking off roads or bridges, to actions that they're taking at fuel distribution sites, or targeting other major infrastructures, or painting over major paintings across various art platforms and all of those things. Their aim basically is to force a conversation that many feel is otherwise not happening at the scale and the urgency that is needed for those conversations to happen. But the political and the media response to all of this has been really strong, and it often frames these tactics not really as democratic expression, but as a threat to public order. And that kind of framing really has some real consequences. According to Global Witness, 42% of climate activists arrested since 2019 were targeted under laws that allow the police to place special restriction on these protests. And peaceful climate protest in practice has been policed far more heavily than far-right activism. And there was a report by Global Witness again that stated that environmental activists were charged at 3 times the rate of far-right groups. The Guardian has even described the UK as a world leader in the legal crackdown on climate activism. And if you think about it, these powers don't really stay confined within climate protesting, which is the focus of today, but we've seen a lot of this applied to, marches for Palestine or the Black Lives Matter movement, not just within the UK, but across different jurisdictions as well. And that suggests that this is becoming more violent and it's spreading at a faster rate than we can even imagine. So right now we're in a moment where criminal law and police powers and civil injunctions are increasingly being used to manage these protests. Next slide, please. So before moving on to discussing the domestic legislation within the UK, it's helpful to take a step back and look at the international framework that the UK has signed up to, particularly the Aarhus Convention. So Aarhus is basically the backbone of environmental democracy in Europe, and it gives people 3 core rights, which is access to environmental information, participation in environmental decision-making, and access to justice. But for protesting, this essentially protects the people that are exercising those rights. So the key provision here is Article 3, Section 8, which requires that anyone engaging in environmental activism or participation shall not be penalized, persecuted, or harassed in any way for doing so. And in simple terms, it recognizes that it essentially puts an explicit duty on states to ensure that activists don't get punished for raising environmental concerns. And this is an important context because the UK trend at the moment is moving in the opposite direction. As climate activists continue to face criminalization. So essentially, the Aarhus Convention gives us kind of a benchmark, and it acts as an international commitment that environmental defenders should be protected and not targeted. And when we look at now what is happening domestically, which we'll get on to next, it becomes clear that there's a growing tension between the UK's international obligations and its current protest policing framework. So with that context, we'll now talk about the Public Order Act 2023, which is essentially a legislative response to, from my understanding, the exact tactics that are used by these climate groups. And in the different sections, it introduces a series of different offenses. So for example, in Section 1, locking on is not allowed. Section 2 and 4 say that basically specify on equipment offenses. Section 3 talks about tunneling. Section 6 talks about obstruction of major transport works. And again, these are very, very specific to the acts that have previously been conducted by the different tactics used by these environmental groups. And to further add on to that, we have expanded police powers. So specific to Section 10 and 11, protest-related stop and search has been identified, and this also includes suspicionless stop and search in certain circumstances as well. And further, sections 13 and 17 talk about serious disruption prevention orders, which can restrict someone's future protest activity, even if they have not really committed an offense in the protest that they are talking about in the moment. And under Section 14, we also see a lower threshold for what counts as serious disruption, and that gives the police even more room to step in. Earlier this year, in this case, Liberty challenged the Home Secretary's attempt to push this threshold even lower through new regulations, and the court agreed that it had gone beyond what the Parliament allowed. And in other words, basically the government tried to stretch the protest policing powers further than the law was permitting. This shows that even after the Parliament reduced the threshold, the government was still trying to cut it down again, making it easier for the police to intervene in protests wherever they can. And the implication for that is that the bar for stopping or restricting a protest is becoming so low that even peaceful or minor disruption could trigger police action, which is quite scary. So taken together, these provisions raise real civil liberties concerns, which are the proportionality of these restrictions, the potential chilling effect on legitimate protest, and the ease with which these powers can extend beyond climate movements as well, as previously mentioned. Next slide, please. So that basically was the legal background about everything, but it's also important to look at how these laws are now operating in practice. So, for example, Just Stop Oil prosecutions have pushed the limits of criminal liability for disruptive protests. And one of the clearest trends is the ways that the courts have restricted the use of climate necessity defenses or vital contextual evidence, meaning that activists are often prevented from explaining why they acted the way that they acted. And now, like going further, we're even seeing convictions for obstruction, breaches of police conditions, and again, the new Public Order Act offenses. And on the civil side, shell against persons unknown is another major example. The High Court here granted wide-ranging injunctions covering fuel sites and access routes and corporate property. And crucially, these applied not just to named activists, but to persons unknown, which we'll talk about going forward. So these are basically people and groups that were not identified and who might never even have participated in the protest, but they were still being subjected because they were, either within the area or somehow affiliated with the act as well. So it's really interesting because now we're seeing a hybrid legal response, which combines criminal prosecutions as well as broad civil injunctions as well. And I feel like that really does tighten the space for protest even further. Next slide, please. So as I mentioned, persons unknown injunctions have become really, really powerful for these kinds of policing of protests. They are essentially preventative civil injunctions that are aimed at unidentified individuals who are likely to engage in these kinds of acts. Normally, they have to be served on actual people, or at least a defined group. But here, the court allows restrictions that apply to anybody that is, again, like I said, entering a certain area or engaging in certain actions. And this was first seen in the case of in the case of Wolverhampton City Council and others against London Gypsies and Travellers, which confirmed that injunctions can restrain all persons from a particular place or activity, even without serving or identifying them. And these are used extensively by corporations and public bodies to protect infrastructure, allowing private actors to create their own bespoke public order rules around their sites. And in practice, this enables companies and councils to basically control the space in which that they're operating more tightly than criminal law alone ever could do that. So following this case, and within this case as well, groups like Friends of the Earth noted a substantial increase in these injunctions, and they were not only being applied to that particular group, but going forward, these are being applied against environmental protesters as well. And the court itself acknowledged the broad significance of using this type of injunction because anonymity is common, whether these are protesters or people that are acting online or offline. This expands and can expand into many different contexts where, the court would need major evidence to prove who these wrongdoers are, because it really can be anyone, essentially. And this raises clear questions about fairness and proportionality, and whether someone can even realistically comply with an order, that they don't know exists. So because of all of this, there's a huge debate about the impact of these kinds of injunctions on lawful protest and political expression as well. I'll hand it over to Carol now.
Thanks, Tanvi. I'll just share briefly about sentencing in my presentation segment. The video mentioned that sentences are very long now for protesters, and there is this case called Hallam and others, which covered a number of protest cases, one of which was protesters who were charged with a conspiracy to cause a public nuisance because they had planned to disrupt traffic on the M25. And by the way, our panelist, Owen Greenhall, was involved in this case. So in this case, on appeal, the court reduced the sentences of the protesters, and this was because the court considered the initial sentences manifestly excessive. There are some legal points that we can take away from this appeal. First, the court considered that conscientious motivation was relevant in considering the culpability of the offender. The court would consider whether the protesters' motives to communicate their views about the appropriate response to climate change issues caused them to protest in the way that they did. And second, the sentence imposed must not cause a disproportionate interference with the rights to free expression and assembly that are protected under the ECHR, the European Convention for Human Rights. But the court did say that the fact that the appellant's expressions of opinion involved criminal trespass weakened the protection that they deserved under the convention. And in the appeal, the court was of the view that the sentencing judge's remarks showed that they didn't take into account the appellant's conscientious motivations and also did not consider the protection under the convention. And so the appeal reduced the sentences. And throughout this case, there was also the involvement of the UN Special Rapporteur Michael Faust, whom we saw in the video. He released statements about of concern about the long sentences for protesters and restrictive bail conditions, which included prohibition from contact with any co-defendants and restrictions from participating in any climate change demonstration at all. The rapporteur pointed out that the UK has a binding obligation under the Aarhus Convention to ensure that persons exercising their rights in conformity with the convention are not penalized. But the UK government responded to say that the protesters are not exercising their rights in conformity with the convention, and therefore there is no obligation under the Aarhus Convention that is being triggered to not penalize the protesters. In the Hallam and others case, the court also held that it would not be appropriate for sentencing judges to have regard to the Aarhus Convention or the views of the UN Special Rapporteur because first, the Aarhus Convention is not incorporated into English law, and the court also said that the Article 3.8 of the Aarhus Convention, which we saw earlier, did not apply because the protesters were being penalized for committing criminal offenses and they were not penalized for exercising their rights in conformity with the convention. And although the sentences for the M25 protesters charged with conspiracy were reduced, the court did not take so kindly to the case of the protesters who were involved in the sunflowers case. This is where two protesters threw soup at Vincent van Gogh's sunflowers paintings in the National Gallery, and they were sentenced to 24 months and 20 months imprisonment. The court said that it is ludicrous, self-indulgent, and offensive for protesters to call themselves political prisoners. And this was offensive to people in other parts of the world facing persecution, imprisonment, and sometimes even death for their beliefs. These other places have no just laws and democracy. And in this case, the court maintained the protesters' sentences. Yeah, so a food for thought about the comparison between what's happening in the UK and other countries. And this is just a very recent update from last week, where the Justice Secretary announced that jury trials will be scrapped for crimes with sentences of less than 3 years to reduce the backlog with jury trials. There are, of course, concerns about the implications for justice and whether people would be distanced from legal proceedings. Together with the issues on restricting evidence that can be presented to the jury at the moment, changes like this also raise concern about whether the jury will be involved and how criminal justice will play out for protesters. I'm going to leave Tanvi to conclude with the last slide.
Sure, thanks, Carol. So basically, to close, we're now looking at a protest framework in the UK that is shifting towards preemptive control and disruption minimization. And the state isn't just responding to that disruption, it's trying to prevent dissent before it happens using a blend of criminal law and civil law. And this really does raise fundamental questions like, what forms of protest even remain lawful at this point? And how do we even balance freedom of expression against public order when the tools being used to manage those protests are expanding on all of those fronts? The courts are being pushed to mediate between economic risk and protection of the infrastructure and political expression and the rights of activists. But the space for meaningful dissent essentially is narrowing even further. And I really think that climate activism especially is going to be on the front line for looking at these tensions. And yeah, it really does just make you wonder, where do we go from here, as was echoed in the documentary that we just saw as well. So I think with that, we will move on to the panel discussion. So I'll just hand it over to my team now.
Thank you, Tanvi. And with that, could I invite Orla and the panelists to take their seats at the front? I hope the video, the breakout discussion, and the presentation were a good setup for our panel discussion.
Thank you, Carol. Can everybody hear me okay online and in the room? Can you hear me at the back? Or will I use a microphone? Okay. Hello? It's on? Great, thank you, Riley. Thank you to Carol and Tanvi for that presentation, which has really nicely sort of set the context, given us all the sort of background legal knowledge that we need to hopefully now delve into some of these legal issues a little bit more discursively. We've got a really excellent panel here this evening with a great variety of backgrounds spanning activism, academia, and indeed legal practice as well. So I hope we'll be able to sort of delve into the issues from a few different perspectives and also hear from people who don't traditionally come from a legal background. I think the thing about even what we see from the video, people end up confronted with the law when they probably never intended to or thought that they would be, and end up having to learn quite a bit about it in practice. And I think, Clive, to introduce you first, you're a perfect example of that as a non-lawyer by trade. I think you have a background in STEM, in engineering, so this really was not your sort of wheelhouse until you became involved. But you're here in your capacity as spokesperson for Defend Our Juries, whose sort of raison d'etre is to resist actions that undermine trial by jury and to sort of emphasize that constitutional safeguard. And we just saw on the presentation there that there's some pretty troubling updates in that world. So I just wanted to introduce you and invite you to introduce yourself and to tell us a little bit about, given that you went from not being involved in law at all, as I understand it, to, as we saw in the video, ending up being thrown in a prison cell. How did you get involved? How were you so motivated to do so? The judge thought that Roger Hallam pressured you into doing it, but I don't think that's the case. So maybe you can tell us a bit about how you ended up here.
Hello, everyone. Thank you for coming along today.
This might work. This one works.
Okay. So thank you for coming along today. When I heard that people weren't being allowed to explain their motivation in court, I just thought this is just fundamentally wrong. This is not British justice. This is not the legal system that I've been brought up to believe that would be there for me if I was accused of anything. And so I felt motivated to go out and to go onto the streets and to protest against this. That was in 2023. That was the beginning of me going through a process of working out what the law allowed, what the law didn't allow. I had done some of that background work before. I'd done some protesting with Extinction Rebellion, and we'd seen the various bits of legislation in 2022, 2023 that they went through and restricted areas of protest. We went through as Defend Our Juries, that the organisation being formed, and in 2024 I was in the High Court at the point where Justice Sayani said, no, this is completely wrong. What's written on the sign, that is the law, and it is reasonable for somebody to stand outside of a court with a sign stating the law. You'd think it's bizarre you have to go to court in order to be able to verify that, but that's where you are. And over the course of time, we've seen more and more pieces of repression. One of the gentlemen that you will have seen in the film, who was stood next to Michel Forst, the UN Special Rapporteur, is a gentleman called Tim Crossland. And he's one of the other Defend Our Juries spokespersons. He, recently this year, he was arrested at home, arrested a couple of hours before he was due to do a press release online. And he was arrested under Section 12 of the Terrorism Act. We can see the escalation in sentencing that's gone through, where in 2018, there were people who were charged, who were given a prison sentence because of fracking, and the Court of Appeal threw it out and said, no prison, and they were given conditional discharge. And then you go through and you see Morgan and Marcus, 2 years, 7 months, and 3 years. And then you go through and you see the Hallam case, and you see 5 years and 4 years reduced to 4 and 3 on appeal. And now you can see that the upper bar, whereas it was before 10 years for public nuisance, we're now shooting up to 14 years, and they're involving terrorism. So all of that is the things that pushed me to be where I am now, which is absolutely not where I expected to be. And the only way that you stop the government from acquiring more and more powers and from pushing ordinary people more and more out of the decision-making space is that you speak up to them. And that's what I'm doing with Defend Our Juries. That's where I am today. Thank you.
25. Yes, that deserves a round of applause from the get-go. Then on the other hand, we have Sarah Finch, who, as I understand it, has been involved in activism since the 1980s. I think primarily a lot of climate and environmental activism, but also sort of global inequality, debt cancellation issues as well, as I've read. But you're also not a person who really, as I understand it, was doing things through the law, as it were, until very recently, with challenges to persons on known injunctions, and then most famously, people in the room may be familiar with landmark Supreme Court case last year, Finch versus Surrey County Council. We have the eponymous Finch with us in the room. You sort of were an activist, were concerned, you were concerned with social justice, but you sort of turned to the law to get an answer on something. I wonder again if you could sort of answer a similar question as to how that came to be, and with that litigation, you know, was there an element of sort of what we'd call traditional protest as well, and then the sort of legal action parallel to that? And maybe in doing so, Sarah, you could, for the unacquainted in the room, say a very small bit about that litigation without getting too into the weeds of planning law. But yes, how you ended up doing that would be very interesting.
Does this work? Yeah. Okay, thanks, Orla. Yeah, so yeah, I've got mixed feelings in this discussion because I'm sort of a rare example of a climate campaigner that's had a very positive experience of the law, but as well as seeing all the negative sides of it. So yeah, just my case, which I brought on behalf of a group called the Wheeled Action Group. I'll mention a bit more about them in a moment. So I was the named claimant on behalf of the Wheeled Action Group in a legal challenge to planning permission that had been granted for expansion of an oil site in Surrey. It was a little oil site with 2 wells. And in 2019, Surrey County Council gave it permission for 4 more wells and 20 years of production of oil, 3.3 million tonnes of oil to be produced. And we thought, well, no, that can't be right in a climate emergency. And we're pretty sure it wasn't lawful either. So we took a judicial review over that case, and it went up all the way through the UK legal system, through the High Court of Appeal, losing every time until finally the Supreme Court. And we found out last June that we had won our case. So the basic facts of the matter were that planning permission for that expansion of that site in Surrey was unlawful because the council hadn't included in its environmental impact assessment the emissions, the greenhouse gas emissions that would arise when the oil was eventually burned. So that's called like scope 3, the combustion emissions. And as it was a Supreme Court, that's therefore the law for the whole of the land. And that meant that a whole lot of much bigger developments also got found unlawful. So including the Rosebank oil field in the North Sea and the Whitehaven coal mine. And the government had to rewrite guidance on for the offshore oil industry on how to apply the new ruling. And also it's now having effects in other sectors as well. So like a huge win for the climate, hurrah. But that basically came out of the Wheeled Action Group's campaigning for many years before against, where we were in Surrey and Sussex was a kind of epicentre of the fracking boom of the 2010s, and we had many applications for fracking type oil and gas developments dotted around in this mostly rural area. And the means of protesting, of campaigning against those was by and large the traditional direct action that we've been talking about, locking on, slow walking lorries, climbing onto tankers, etc. So that's what the Wheeled Action Group sort of member groups, where a lot of them were doing. So famously in Bolcombe, maybe many of the people in this room are too young to remember Bolcombe, but that was like a whole summer of direct action in Sussex, which was very high profile and brought this sort of scandal of these new fracking methods to national attention. And then the Bolcombe site, actually, they kind of ran out of time to implement their planning permission, so that threat sort of receded for the moment. And then Horse Hill was the next one, where we saw lots of direct action, protest camps, site occupations, lock-ons across the gates, etc. Many people arrested. So not including me. I took part in some slow walking, but I wasn't really very much involved in the direct action. But I was involved in supporting the many people who got kind of arrested and went through trials, and saw how much of an impact that has on people's lives. And bearing in mind, this was before the recent changes to the law, so the kind of penalties those people could expect were less than they would today. And we had a persons unknown injunction brought at the oil company that was operating the Horse Hill site, and several others took out a very wide-ranging injunction against persons unknown, which stopped people doing all kinds of very normal lawful activities in 4 different locations. And as it was against persons unknown, there was no one to defend it. So 6 women from the Wheeled Action Group put themselves forward, not including me, 6 other brave women said, right, we're the defendants now. So we had a more than 3-year legal fight over that, with many hearings, both in person and online, because it was in COVID era. And we did succeed in scaling it right back. So instead of being against persons unknown, it was against 5 named individuals. And instead of being about 4 locations, it's just 1. And a whole load of the activities like slow walking, walking in the road, etc., is struck off. So we did succeed in limiting that down. So sorry, I've probably talked for too long, but just to say, I've sort of experienced both sides, the kind of respectable objecting to planning applications and going through the courts kind of campaigning, and supporting direct action. And I wouldn't say that I sort of saw the light and decided to do one or the other. It's a matter of what can we do now in the situation we're in. It wasn't a decision to turn to the law, but it was like, oh, this terrible project's just been given permission. What can we do to stop it? And at that point, the only way we could see was to use the law. So it was a tactical rather than a kind of strategic decision.
Mm-hmm. Yeah. Talk about having a positive experience with the law. Winning in the Supreme Court is about as good as it gets. So, but no, I think it's quite interesting to have you on the panel, because it's a suite of options available really to climate activists, and sometimes it will be more traditional protest, on the streets, or it will be in the courts. So that's what you ended up doing, and obviously to great success. I'm going to jump over to introduce David White, Professor of Climate Justice at Queen Mary University. His research explores the relationship between capitalism, law, and corporate power, with a particular sort of lens on climate and environmental breakdown. And David, you're currently undertaking some research on sentencing of protesters and activists and trends there. So I'm wondering, do you want to sort of introduce your general academic background, and maybe with an emphasis on that research, which will be very relevant to what we were just viewing?
I will say something about the research. I won't say anything about my general academic background,
that's okay,
because that's a bad question to ask anyone who wants to talk about themselves. So I won't do that. But I will say it's a real pleasure, Orla, to be on the panel with you. But particularly with the other panelists, we've got 2 people who really, putting their bodies literally on the line. And I didn't know that about Sarah's background in the very historic Balcombe fracking movement, actually. And Clive made a very good point about what's changed since that point. And of course, with a lawyer who's got his hands really stuck into defending people. So I'm definitely the least interesting panelist, but I'll try and say some things now that might be of interest. Really, just to reflect on the presentation that we've just heard to start off with. Look, I think this is a really important point. This clash of civil and criminal laws that's going on, that are mutually reinforcing themselves. That Sarah was just talking about how she challenged that particular persons unknown injunction. We, as part of this project, are just trying to track specifically people who've been imprisoned, and I'll say something about that in a moment, very briefly, because nobody's doing it, you know. But I want to say nobody's also tracking, and I mean, there's nobody. Of course, we don't rely on the legal system to do this. We don't rely on the government to do this. You know, they introduce all of these restrictions and all of these new criminal offences. They don't track how they're. Nobody's actually working out what's happening. So, you know, in a way, activists and academics have to do that. And I tell you, the thing that makes it most clear to me, we asked a freedom of information request of the Department of Justice. A very simple question. We asked how many injunctions have been taken out against, and we asked for persons unknown injunctions and named person injunctions that have been taken out against environmental, or to prevent environmental protest. And we got a very quick. I mean, some of you will know this, what the answer was going to be, and we kind of guessed it. They're not keeping any record. They asked us to go back to every single individual court in the land to find out, because they're only held. That was the answer we got. Though they are only held by individual courts, they have no idea what the impact of this is. They don't actually care. The government does not care what the impact of this is. There's a lot of posturing going on, and I think that's the first thing I want to say. The other thing I want to say is, as part of the project that Orla introduced, we hope to publish a report which just gives an overview of people who've been jailed, who've had custodial sentences, but also who've been held in remand for longer than a day, who've been denied bail. But a large number, I can't give any figures now, a large number of those are people who have breached injunctions. And most of them, I think, when we look at it, we'll find out that these were people who didn't know. Many of them, if not the majority, won't even know they were breaching an injunction because they were never named in the injunction, and the injunction has got conditions that are so broad. And I think that's a really, really important thing to recognise, that a lot of people have gone to jail for breaching those injunctions that the government isn't even bothering to track. It's incredible. It's absolutely incredible. The level of violence in the penal system that we can see, and it is violence when people are forcibly locked up in those circumstances. I find it incredible. I mean, I suppose that the last thing I want to say, the last point I want to make is in response to one of Clive's points. He's absolutely right about motive. But I do want to say that I think it's really important. Some of the law students and researchers and academics in the room might know Alan Norrie's book, Crime, Reason, History. I think it's a really important book, and it explains how motive historically was removed from criminal trial. And it's removed because you cannot have context in a criminal trial. If you have context in a criminal trial, it means that you can steal a loaf of bread and say, I was hungry. So you can't have it in a test for a test of guilt or liability. But what you can do is you can have it in sentencing, as we've heard, right? And so what's happening is that and you can put any argument to a jury. And the jury, of course, is the jury is the pressure valve in the system, the only pressure valve, the only thing we have that makes it a little bit more democratic. I don't happen to think we're ever going to get justice, even if we had juries in every case, because the law, the form of the law, is set up in a way to claim to guarantee equality, but always guarantee inequality. But that's a much bigger discussion. Juries are worth defending because it's the only aspect of democracy that we have. It's the only way in which people can say, I acted on conscience, now you can decide whether I'm guilty or not. A judge cannot do that. It's impossible. So the law is set up in that way, and that's why they've tried to squeeze out necessity defence, justificatory defences, because it's the only way in which you can bring the reality of the social content back in. So I think I want to end on that, but I'll actually give you a couple, because you did say that, asked me to say about the research. We don't have the figures now, but we know of the people who of people who've been sentenced, and that's anything between 80 and 100 people. We think that we're pretty sure that the results will show. Don't quote me on this, because this is like a kind of, this is the last thing any researcher should do. But I think I've got a responsibility to just give a broad indication. Certainly more than half of those custodial sentences, and this is since 2000. Certainly more than half of those 2019. There was a couple in 2019. Certainly more than half of those will be 4 months or longer. Certainly more than a third will be a year or longer. That's what we're talking about. So it's not just the cases that we saw here. I mean, we're talking 3 figures, and those cases are rising. When it comes to the Palestine Action cases, they're the ones that are going through the court now. There are people who are going to be jailed for a long time. The CPS are asking for many more years than some of the climate protesters that got for some of those Palestine Action protesters for trying to prevent a genocide. We have to ask what it is about our legal system. Not that it responds in a peculiar way, because as I've tried to articulate, this is the way the criminal justice system is designed to respond, and I think that's we're at the highest point of its punitiveness, but that might also not. This might not be the end of it.
Thank you, David. So much to respond to there, but as you say, we were speaking the other day about sort of an absurdism, you know, as we see it at the moment. You know, and I want to ask some of the activists about this in a moment. It's just feeling very fatalist and worse and worse. In fact, sentencing inflation is something you've been looking at as well, isn't it? Over time they've been just getting progressively, like for the same offences, the same sort of protesters, they've been increasing at a sort of trackable rate. Is that correct to say?
I can't give you any broad percentage, but I can say that Clive's absolutely right. You know, the fracking case that he talked about that goes to the Court of Appeal and gets thrown out. Now we're looking at 5 years for going to a Zoom meeting to plan a protest, getting reduced from 5 years to 4 years. I mean, come on. This is really so. Yeah, we will be looking at that, and we'll also be looking at the kind of tariffs that have been given for those offences generally. So, for example, you know, there was, I think 4 people were sentenced to a year imprisonment in Scotland for the Thales action. Yeah, some of you might have come across that, for breach of the peace. Breach of the peace. I mean, people don't get sent to jail for breach of the peace on a first offence. That just doesn't happen.
And I'll just ask you this, because I know you have to leave slightly early. This research, it's being done. Where is this project based, and where can people find it if and when it is?
This is great.
Yeah. Is this too much? Maybe
no, it's not too much. But I'm going to end up about 8:05 running out the door, and so it's good. Maybe the discussion.
That's why I'm
doesn't
sort of
come
front
back to
loading.
me.
Yeah.
Maybe this is my last contribution. But yeah. So it's Queen Mary, University of London, the Department of Law, and my research centre, which is the Centre for Climate Crime and Climate Justice. But we're working with people from Defender Juries, from the activist group Just Stop Oil, XR, people who've been involved in those in the past, because actually that's the only way in which we can kind of compile the data. You know, it's never these things. I mean, this is, I think, a lesson for law students. You know, not just the injunctions, but generally. Outcomes, legal system outcomes are really not tracked, and actually very few of the judgments we've heard from some of the judgments earlier, very few of them are ever published. So I'm also relying on people who went along. I'm relying on a lot of journalists, and you've got to be careful with that, because journalists report cases wrongly. So you have to be careful about using that data. And I'm relying on a lot of other activists who went along and recorded those trials themselves. So we've kind of managed to pull together. It is a very interesting methodological question. Obviously, I'm an academic that would come back, but if we were looking at the mine, look, I know someone who did the same thing in the miners' strike. I mean, obviously, a long time ago. He's retired now, Paddy Hilliard, and he was able just to contact the lawyers that were representing the miners, because there only was 2 or 3 law firms representing the miners, to track all the stuff that we will hear about soon in a public inquiry about Orgreave and the way the police were and those. But we don't, this is not the case for this. So we need to, I think the lesson I'm kind of learning is that I think the movement has to start tracking this stuff more systematically. That's not criticism of the movement, because the movement has to react and defend its people, first and foremost. But I think that's something we can kind of learn, or academics can learn. Maybe academics should be tracking this stuff and recording it right from the start.
Yeah, and talking about the suite of things that activists have to do, be it litigation or on the streets, that tracking point and that academic point it's part of that suite of things that need to be done. It's another tool really.
Yeah.
So it's really very important.
Yeah, you're right.
I would now like to go to Owen, of course, Owen Greenhall, who is a barrister at Garden Court Chambers, who works at the intersection of public law and criminal justice. And
another 10 minutes.
Sorry. I was just going to say public law and criminal justice, and I think it might be fair to say increasingly climate justice as it intersects with all of this. Owen has represented Just Stop Oil protesters, members of Greenpeace, has acted in Persons Unknown injunctions. And beyond the courtroom, he's the co-author of the Protest Handbook, which is the leading practical textbook in this field for practitioners. And he also does some training for activist groups on sort of navigating all of these legal oddities that we're talking about. So welcome, Owen. It's great to have you on the panel. I'd like to return to what I just said there in terms of this increasing overlap with climate justice. When you started working in this field, I imagine there was much less of this sort of work, but increasingly, you know, there's the freedom of expression part of the Venn diagram. There's the there's the criminal justice part, and now there's also the climate justice part. Is it sort of almost becoming its own sort of practice area for you with its own unique challenges? Or do you want to talk a little bit about your work generally in that practice area?
I mean, I think environmental protesters in particular have always been very active in the courts and have been very keen to take test cases, whether that's criminal appeals or challenges in the civil courts. Not exclusively so. There is a long history of other activists doing that. In terms of where we are now in relation to climate justice in particular, it's very clear that the legislation in the Public Order Act was directly targeted at Just Stop Oil and XR and those kind of groups, and it is a very clear difference in the attitude of the government in terms of, rather than seeing the problem as being a public order problem, which is common to crowds at football grounds, parties that get out of hand, whatever it is, and protests in amongst that, singling out protest as a specific problem. The word protest never appeared in legislation until there was one mention of something in the COVID regulations, and then in the Crime Sentencing and Public Crime Sentencing in Courts Act 2021 or whatever it is, it was the first mention of the word protest in relation to the power of the police to put conditions on one-person protests. So one person who is being noisy because they're protesting, the police can stop it. One person who's being noisy because they're very happy, the police can't. And that shift in seeing protest as the problem and the tactics used by protest as the problem, rather than just a general issue about public order, is a complete shift in the attitude from the government, and is something that's very much targeted at environmental cases.
I think Tanvi in her presentation used the word framing protest as public order, a public order issue, and that's exactly what you're describing. And it's sort of an irony that, you know, as you say, there are these freedom of expression concepts tied up in protest, and yet it is this sort of public order that is being emphasized as a problem. I wondered, would you talk a little bit about, you know, because I know this is also an issue, you're working in the Palestine action, legal action as well, about this tension between criminal justice and public order, criminal justice, and Article 10, Article 11, freedom of expression. How are the courts looking at that? Why are we in this sort of topsy-turvy place where these are the most problematic public order crimes? Where's the jurisprudence there, I suppose?
I mean, I think there's the criminal justice system in the area of free speech took quite a lot of time to catch up with the changes brought in by the Human Rights Act and the embedding of Articles 10 and 11 in domestic law. The fundamental tension is whether or not, when considering an individual case, there needs to be a specific assessment of the proportionality of conviction. So every stage of the change, so from arrest to the decision to prosecute, to decision to convict, to sentence. And does the court have to consider, is it proportionate to find this person guilty of a criminal offence for what they've done? Is it proportionate to sentence them to a community order for what they've done? And the courts are so keen to exclude particularly defences to liability on the basis of human rights, that they are always looking for shortcuts. And they will essentially say, well, if these elements of an offence are made out, that will automatically mean a conviction is proportionate, and therefore you can find them guilty without having to consider free speech at all. And sometimes they will say, well, there may be a defence of reasonableness, and you can weigh in the balance, is what the defendant did reasonable before you decide if they're guilty or not. But the power of the European Convention and the power of the proportionality defence is it puts the focus on the state's response to protest rather than the conduct of the defendant. I mean, in a one-liner, you could have someone who is behaving very unreasonably on a protest, but it's still disproportionate to convict them because they are exercising free speech. And the courts, ever since the Supreme Court decision in Ziegler, which really opened up this space for proportionality defences, have been trying to close that line of defence down at every stage and restrict the ability to justify what might otherwise be criminal conduct on the basis of free speech. And that it's very out of sync with the case law from Strasbourg. The most recent cases from Strasbourg are clear that you always need to have a fact-specific assessment of proportionality, of conviction. There are even recent cases where there have been found breaches of Articles 10 and 11, not because objectively a conviction was disproportionate, but because the domestic authorities failed to consider the issue of proportionality. So it's like a procedural defense, that simply because the domestic court didn't weigh up the relevant competing interests and decide for itself, is this conviction proportionate? Strasbourg says, well, we're not going to even make that assessment ourselves. The procedural requirement is breached, therefore we find a breach. And that's a very powerful line of authority. It's not being reflected in domestic authorities.
And I imagine the answer to this is probably no, but just with this climate justice intersection, you know, the ICJ advisory opinion, Klima Senioren at the ECHR level, does any of that permeate down at all to criminal justice?
Well, you mentioned the Hallam sentencing appeal, where we tried to rely on the Aarhus Convention as one of our grounds. The Court of Appeal gave us fairly short shrift with that, and when, for unsurprising reasons, weren't keen to open up the scope for those sorts of defences. But one way in which I think it might be arguable that it's relevant is, generally speaking, the courts like to present themselves as neutral arbiters of competing rights. And so if there's a demonstration, there are two competing viewpoints, the court will say, well, it's not for us to take one side or the other, whether it's, you know, abortion rights or whatever it is. And so that the court will sort of stand back and say, you know, we cannot pick a side. There is a difference between content neutrality and viewpoint neutrality, and this was set out by Lord Justice Singh in the High Court decision in Ziegler. Essentially, the court can give weight to the general importance of the debate, but not but still not pick a side. But if you have an international convention which the government has signed us up to, the Aarhus Convention, you know, we as a nation are signed up to that. That is legislation that is at an international level has been ratified on our behalf. In those circumstances, it seems to me that it's okay to say the court shouldn't be neutral. We have signed up to the Aarhus Convention. We have obligations under that. Therefore, when considering issues related to climate change, the court should take the side of those who are standing up for environmental issues. And that may be, you know, in the right case, and a point where you might get some traction.
Okay, a nice hopeful point. I want to go back to the sort of activism angle and this sort of increasingly hostile landscape that activists are met with, be they these targeted reforms, you know, the rising use of these injunctions and the threat of contempt of court, and of course, increasingly now, or lately, I should say, the use of terrorism legislation. It feels like we're in a bit of a moment, and it feels a little bit scary, perhaps. I wanted to ask maybe Sarah and Clive, you know, how does it feel sort of being an activist right now? I mean, I know, Sarah, you mentioned you don't, you know, always play that role of going out and getting arrested, but even from your networks, from your circles, you know, do you feel the chilling effect sort of taking hold?
Yeah, well, as you said, not personally because I haven't been involved in that kind of campaigning, but definitely people that I know, there is a chilling effect. And we saw it already back with our injunction at Horse Hill. It's a kind of, people aren't confident, they don't know what they can do. People have a red line, some people don't want to get arrested or whatever, and they literally don't know how to avoid that. So that puts people off. And I think another thing recently, I know from people involved in XR that I know, they're now seeing so many people are now campaigning on Defend Our Juries and on against the Palestine Action prescription, that it's reduced the pool of people available to do action on climate. So campaigners' time is now all being sucked into defending the right to protest rather than actually protesting the things they want to protest. So yeah, I think it's a very sort of hostile environment for campaigners from my perception. Yeah,
having to spend time on that sort of proxy fight. Yeah,
and having to learn up, become experts on all of these things that, you know, these very well qualified people have been talking about. Now, you know, your average person is like, oh well, am I going to be in breach of this or that, or is this criminal? You know, takes up a lot of their energy and emotional energy, and I think it's very damaging to people's mental health. I think worrying about it, and then people who are arrested and they have these lengthy waits for trials, sometimes years. They have bail conditions, which means they can't go to maybe the place where they live or where their family live. Even if they end up sort of being acquitted, they've had years of living under this horrible pressure. So it all very unhealthy.
And Clive, you know, with your experience as well, just speaking about that sort of emotional toll that this kind of work takes, you know, what's your response to that?
I've seen people who've been involved in the whole protest movement, whichever type of protest it is, for quite a while now. And seeing people who have spent the last 5, 6, 7 years going through one court case after another court case, where they're preparing for one court case and they're going along and they're all prepared and they're all ready for it. And then they're told, actually, no, sorry, it's not going to happen today because we don't have a prosecutor or we don't have a spare courtroom. And then they have to, all the things that they got ready for it, they have to put all those on hold. They have to get themselves ready again. If it's a case where potentially they face a custodial sentence, you have to be prepared, ready that you might not go home. What are you going to do if you don't go home? Who's going to look after your house? You might lose your job, so you have to talk to your employer about it. So there's a lot of kind of emotional stress that's involved in pushing yourself forward through a court case. And I am seeing more and more people who have been through several steps of this, and frankly, they are mentally worn out. I remember one person, I saw them when both of us were supporting somebody else at a court case. And at lunchtime, I thought, well, this opportunity to talk to them about their forthcoming court case. And I started having a conversation with them at court about, well, we should be doing this for it, we should be doing that for it. And within 2 or 3 minutes, I thought, no, this person is not in the right mental place to be able to do that. And what I had to do is just to make sure that they were happy and they were comfortable and that they had the lunch that they wanted. And it was just getting them through that day. And quite often when you see things on TV, you see things in the press, you see the end result. So you will see Sarah jumping for joy at the end of it saying, whoa, we won. But you won't see all the work that happened before that in order to get to that stage. And you won't see the cases where people lost, where they're carted away in a prison van, or where they walk away from it and they have fines that are so large that they have to have a crowdfunder and they're not sure whether they will keep their home or not. One of my friends put around a crowdfunder. They had an injunction and they had to pay off the fine, and graciously the people who had the injunction had said, we'll settle it for this lower sum. So they were trying to get this lower sum together, and if they couldn't, they would have to sell their house. If they sell their house, then they become homeless. They become homeless, well, then they become dependent on the state. That's me and you. So there's a commercial company that can take away money from individuals and then throw them onto the state. That's not the way that the system should be.
I think it's interesting what you've both said about, you know, all of this time and effort having to be put in to have these battles that you don't even want to be having, that you want to be talking about the climate and the climate crisis. And it's frustrating really that there's such a lag between, you know, say Sarah, your success, you know, I think I saw you say in The Guardian, well, what was your response to this win? And you said, like, well, we've been saying this all along, so it's good for them to agree that we're correct. And I think there is sometimes this lag where the government does something unlawful, but it kind of takes so long for the legal process to sort of affirm that. You see it even, for example, with the Liberty case, you know, the regulations more than minor. The Court of Appeal says that is so clearly not what the legislation allowed. But you have to go all the way to the Court of Appeal to get that sort of sensical answer. Oh, and I'm wondering what you think about that sort of time lag, you know, in terms of taking legal action on these questions. It's the same with the Palestine Action case. You know, you have to take a judicial review to see if it was sort of unlawful from the get-go. But in the meantime, you know, the chilling effect is in place.
Yeah, I mean, it's a little difficult for me to talk about a Palestine Action case because I'm instructed in it. But in general, I think it's reflective of the attitude of the police, of the state, that a lot of the trends that we see, where, you know, police are using controversial tactics like kettling was an issue back in the day, using stop and search powers to take people's addresses, that kind of stuff. These practices go and go until finally there's a case, and then there's a case, and the courts say that can't be done, and then the police do something else, and then it goes, and then there's a case, and it's always, it's only when you finally get a good result with the right judge in court who says this has got to stop that anything changes. And what really needs to change is the attitude and the culture. There was I remember back to the G20 protests when Ian Tomlinson was tragically killed. At that point, there was quite a movement to try to change policing and to bring in a human rights-based approach to policing and change the public order training. That lasted for a few years, and then they moved on to other tactics and other things, and it just doesn't seem to get better.
On that hopeful note, I'd like to put it out to the room, if in case there's any questions that people would like to ask to any of our panelists for an open Q&A. There's a few online on the Slido, which I can turn to, but is there any hands up in the room at this time? Okay, I saw quite a funny one on Slido, actually. I'd say this is probably for Owen. This was the first one that came in. My Crown Court trial for criminal damage in an XOR protest is currently scheduled for February 2027. What are the chances of being tried by a jury by then? So I suppose it's what are the timelines on these reforms? Maybe you don't know.
I don't know that the reform to jury trial was not a manifesto commitment, and there is still the possibility that the government find it difficult to get it through Parliament. In terms of its implementation schedule and how it will impact on trials that are in progress, where mode of trial has already been determined in favour of jury trials, I think it will be very complicated to reverse mode of trial for cases where that's already been decided. I mean, in terms of the proposal to restrict jury trials in general, it's a preposterous idea, and it will not end the backlog. What will cure the backlog in the criminal courts is investment in the criminal justice system at all stages. There are courts sitting empty because there are not either prosecutors or judges or defend barristers or whatever to hear the cases. They just needs more money. The amount of money it's going to cost to set up something new, if that was all just invested in the criminal justice system, there are plenty of keen young barristers out there who would get through the backlog in about 6 months. I mean,
is there any argument for the reform, you know, from your experience of practice and seeing justice being delayed, you know, justice delayed is justice denied? Is this quicker, speedier justice at all sort of a redeeming justification, or as you say, it all just comes down to funding really at the end of the day anyway? But is there, you know, is there any sort of chink of light in that sense?
I mean, I think long delays in the criminal justice system are no good for anyone. As Clive said, you know, you should never underestimate the emotional impact it has on defendants, on their families, on others in the campaign. For young people in particular to have something hanging over them, even for a year and a half, at, you know, when they're just starting out in life and beginning to make plans for the future, but have to think, well, it may not happen because I might get a conviction of a type that means, you know, my planned career isn't going to happen. So I certainly would be in favour of things being resolved a bit quicker. One of the sort of unintended consequences of delays in the criminal justice system has, I think, been that people are turning to injunctions because they are quick, and so it was a sort of a consequence of long delays in criminal trials. People couldn't be held on remand for that length of time, so they were generally getting bail. And then the government were looking for alternatives, and one very quick alternative are civil injunctions and contempt proceedings. One of the very big problems with contempt proceedings are the costs involved, because essentially in criminal cases, if you lose, you have to pay costs, but the costs take account of your means. That rule doesn't apply in contempt proceedings, so you have to pay whatever it is the company paid to bring proceedings against you. That will be tens, if not hundreds of thousands of pounds. That is interestingly something that the Law Commission is looking at. There's a consultation process at the moment on contempt in general, and they're very interested in that issue. So it may be something that there is scope for change, but as things stand, that simply making an order of, you know, £50,000 costs against someone, even if the company doesn't enforce it, they still have that very powerful gun to hold to someone's head, and that inevitably brings a chilling effect.
Clive, you want to come in?
Yeah, juries aren't the problem, juries are the solution. You cannot replicate having the wisdom and knowledge of 12 ordinary members of the public. At the point where the law and morality start to diverge, it is juries that will bring the law back to what ordinary people expect the law to be. Now, you might be thinking, well, that's not really ever really going to happen, but you have to remember the people who hid Anne Franks and her family in their loft were breaking the law. And the people who reported her, and the people who transported them off to a camp, and the people who put them into a chamber, weeks before the end of the war, they were all following the law. And that was done by a democratically elected government. And whenever I say that, people always say, well, no, that will never happen again. Last year, just before the election stopped it, there was a piece of legislation going through to say it would be a criminal offence for you to be excessively smelly. And excessively smelly was literally what the legislation said. And it was clearly aimed at homeless people. We need ordinary people to pull the law towards what we democratically expect the law to be. They're not the problem, they're the solution. I was at Isleworth Crown Court. I spend far too much of my time at courts. And the chief judge there was handing out leaflets, and he was handing out leaflets to all the barristers there saying, if your case is a short case, it might be delayed. It might be delayed because we've now received our budget for this year for how many days we can sit. And because there was all these backlogs, we've been sitting for as many days as possible. We got this number of courts, and we've been running all of them, all bar one, and the one that's left over, we've been running that as an administrative court. We've now got the paperwork through that says how many days we can sit, and we've sat for too long. So now we're going to have courts empty in order for us to hit the budget for the end of the year. That's why there are delays. The number of times when we're all sat there in the public gallery, and you can see all the barristers all kind of chatting away to each other, and you're like, what's going on? Well, they had to bring so-and-so from North Yorkshire because that's the prison that they chose to put them in, even though their case is being heard in London. And that has literally happened. And hey, guess what? It takes several hours for a prison van to travel from Yorkshire down to London. It's these superfluous delays around the periphery of the system that cause the delays. I've been there in court, and I see when the jury is in court and when the jury isn't in court. And I see that the jury spend about, half, 2/3 of their time in court, and the rest of the time is taken up with legal arguments. It's taken up with, oh, so-and-so hasn't arrived, or this thing over here hasn't gone the way that we're expecting it. It's these little technical finicky things. I was in court at the point where there was somebody representing themselves, and the judge said, because you're representing yourself, then no one's going to ask you any questions. You're just going to explain to the jury what happened on the day, your version of events. So this is your opportunity. And the person started talking, and they were a bit nervous. They were talking a little quickly, and the judge said, well, excuse me, could you just slow down a little bit? And then we saw the reason he had to slow down is because the judge is taking notes. Because they got rid of the stenographers in order to save money. So that job's now passed to the highest paid person in the courtroom. And he had to slow the pace of them going down because he had to give the summing up at the end. So he had to have his own record of what was said. There are these absurdities. That job, by the way, could be done by the mobile phone any of you have in your pocket. These absurdities that we need to get rid of in the system in order to make it more efficient, in order to spend less money on it. And the final thing I would say is the thing that's sucking most of the money out of the criminal justice system, the thing that's where the costs have gone up disproportionately to everything else, is prison. Why? Because the sentences have got higher. Why the sentences got higher? Because the politicians come along to you and they say, I'm going to be tough on crime. No, I'm going to be tougher on crime. Whenever you hear that, don't hear tough on crime, hear tough on your wallet. Because that's what happens at the end of the day. £53,000 a year is what it costs on average to keep a prisoner in prison. I think it's slightly higher for young people because they also have to provide them with education and those sorts of things. It actually works out to be cheaper to send young offenders to Eden than to keep them in the prison system. And they would have better outcomes, by the way. So when David Lammy comes along with this idea, that, which they didn't put in their manifesto because no one would have voted for it, and says, I want to get rid of juries, I want to take them out because they are the problem, they are the thing that's slowing it down. They aren't. Juries are the solution. Juries aren't the problem.
Thank you, Clive. Very well said. I think I do wonder if there's an extent of sort of punching down by the government, you know, when these disruptive protests happen, and you know, I'm not sure if it was in this clip or elsewhere in the film when you hear someone say get a job at the Just Stop Oil protesters, there's sort of an easy, you know, law and order win, you know, maybe that they're trying to sort of cash in on that sort of vitriol. I don't know if anyone on the panel, you know, sort of has a view on if these reforms are sort of coming from that place at all. Anyone?
I mean, I'm sure the government would like to spin it that way and like to appear as if they're playing to some sort of demographic. I actually think that ordinary people understand very well the issues why people are protesting. Yes, I'm sure it is irritating if you're stuck in a traffic jam when you're trying to get your kids to school or whatever. But ordinary people will say, yes, it's annoying, but we understand why they're doing it. And if there's going to be anyone making a decision as to whether or not something amounts to a criminal offence, there is a strong constitutional reason why that should be a jury that makes that decision, and rather than a judge. It just reflects the values of ordinary people.
I think we might have a question in the room. Kat, we'll take Kat, and then can we take this gentleman here afterwards? We'll take them both together so that they can respond together. Thanks.
Thanks, Orla, and thank you to the panel. It was really just, yeah, amazing event. It's obviously really, really inspiring to hear about the stories of activism, but it's also a bit depressing to hear about the challenges that you face. And I'm feeling like a bit hopeless about what, you know, we can do to help activists or to, you know, protest against the measures that are being put in place. And a lot of legal voices for our members will be kind of commercial lawyers who feel that they probably couldn't necessarily get involved in protests, or they may be arrested or things like that. So I'm just wondering whether you've kind of got any tips on what we can do to help and kind of feel a bit less hopeless without being arrested. I'll pass over.
I've got, oh yeah, it's on. Thank you so much. This is such an insightful, like really interesting event. I have a question for Owen and a question for Sarah. For Owen, and it might be outside your practice area, but I'm just curious whether you see a scenario where the particular changes to the protest laws or the particular nature of the convictions ends up being challenged in the European Court of Human Rights, and whether that's a direction of travel we could end up going down. And if so, how you think the Court of Human Rights might approach it, to the extent that you're able to answer that question. And then for Sarah, obviously Finch created a lot of excitement for climate lawyers. It was a huge victory, but there's some sort of warning signs, I think, in the past few weeks, especially from Prime Minister Starmer, you know, on his kind of deregulatory agenda, trying to strip back planning laws, environmental impact assessments, and whether you are sort of concerned about the potential for backlash there and the potential for the watering down of that kind of landmark victory, and if there's anything we can do to kind of prevent Labour from going down that path, if you think they are going down that path.
Thank you. So your question about what can you lawyers do, I think litigation, I think taking cases against, carbon bomb projects, in my experience, can be very successful. And I think there's plenty of things to be challenged, and they don't always go the right way, but sometimes they do. So it's great. All of you involved in environmental law, keep doing it. Yeah, very worrying. I saw an article in Ends the other day with Starmer saying, or being quoted as saying something like they wanted to scrap the Finch judgment, which is incredibly dismaying. On giving it a bit more thought, I am confident that the government doesn't want to scrap the Finch judgment, at least for fossil fuels, because they went to huge efforts to write guidance to the offshore industry about how they implement that. And I think that was particularly arising in nuclear because of the Fingleton report. And I think the Mr. Fingleton, whoever he is, his problem with the Finch judgment was the potential for having to do multiple EIAs at different stages, which kind of is a possible risk, but they also kind of have to do that anyway in other contexts. And if they do it right, if there has been an EIA at a previous stage in the kind of product stream, they can rely on that again. So I think that's exaggerated. So yeah, I don't think so. And I feel strangely two ways about the Labour government, because I think that Ed Miliband has genuinely done some good things, and I think that the announcement that there won't be any more oil and gas licenses in the North Sea is actually really good and puts us on the right side and one of the first movers in that field. And I hear that Ed Miliband actually did play a pretty positive role at the COP and stuff. So I kind of think maybe he's not bad, but Keir Starmer, dreadful. And I just think, does he actually think that stuff, or does he just really say stupid things? Like every time he opens his mouth, he alienates any kind of environmentally inclined potential voter, which, as we know from opinion polls, is most of them. So yeah, I don't know. I did also see separately, though, another depressing thing yesterday, which was, I don't know if people here saw the result of the case, the judicial review into the permission of Luton Airport, and it was all kind of Finch grounds of the they hadn't counted the emissions from the incoming flights, and they hadn't counted the non-carbon emissions that affect the thing. And the judge there seemed to be saying, oh, because we can't really quantify these emissions, then you don't have to count them, which is nonsense, because you can quantify them. And yeah, so that's very depressing. And I kind of think that's the thing with litigations. You may think you have a big win, but it's not a big win permanently. You have to keep fighting for it. Things can slip backwards, and I kind of personally have more hope for kind of multilateral steps forward. And I know that doesn't look like it's happening with the COP, but there are these coalitions of the non-fossil fuel proliferation treaty and the beyond oil and gas whatever, and there's various different bodies of different countries, some of which have got the UK in, some of which haven't. And I kind of think that's what I'm going to look at now, is how we give strength to these things and encourage the countries that are making the right moves to create new norms then that others will follow.
I'll try and answer the ECHR question first, and then the commercial lawyer question second. In relation to the ECHR, in terms, anyone who's looked at the ECHR case law in relation to Articles 10 and 11, in particular in relation to sanctions on cases in Articles 10 and 11, there was very clearly sort of two groups of two strands in the case law. There were cases that were generally coming out of Turkey and Russia and Azerbaijan and places like that, where protesters were given sentences, like the case of Murat Vural in Turkey. Someone got 12 years for pouring paint on a statue. Ibrahimov in Azerbaijan, it's near enough double figures for spraying fuck on a statue. There's Russian cases where it's sort of 3 years for just turning up at a demo where it got a bit rowdy, and that sort of stuff. And for ages, the United Kingdom was not in that group. There was a sort of separate strand of case law, which was from the Western countries where, Linden and France, where a lawyer gets a slap on the wrist for going on a demo or something like that, and it's all very low level, and what you would have is you get the principles from those cases, but the outcome was always no breach of Article 10, almost always no breach. But then in the Russian cases, clear breaches every single time, and frankly, the United Kingdom is moving from one camp to the other, and there will come a point where a case will have to be taken to say that it's gone too far. I do think, on a more technical note, the procedural protections is an interesting ground of challenge and worth developing, and the requirement on domestic authorities to make proportionality assessments at sentencing stage is probably a fruitful way into that issue. In terms of what can commercial lawyers do, I think that it's important. I would never want to take away from activists from doing the activism. It's that they're the ones who know about the issues. They're the ones who have the creativity and the drive to do things. But I think there are sometimes ways in which lawyers can help. In civil litigation, there is very little legal aid. Injunctions are a classic case. For those who don't know, if you breach an injunction, you will get legal aid as of right for the contempt proceedings. But in order to challenge the making of an injunction itself, there's basically no legal aid. And the cost risk is astronomical. It's 100, 200,000 pounds that you're putting yourself on the hook for. Sometimes, particularly if it's a local authority getting an injunction, they will agree not to enforce their costs, but that still means you've got to pay your own lawyer or find a lawyer who will do it for free. I think that's an area where the skills of commercial lawyers could be very, very useful. The injunctions are based on civil torts, or sometimes even economic torts. It's standard commercial stuff, and being able to help, even if it's just advising people, because it can be confusing for people who aren't trained, and sharing information. I think that applies both in civil and criminal side as well. The new offences are not straightforward, even for trained lawyers. Going into the terrorism sphere puts yet another kind of layer of complexity on things. So I think sharing information and that sort of stuff is useful as well. But I would be led by the activists as what they want.
Clive, we're a little bit over time, but would you like to answer as to how people can help? And then unfortunately we'll have to wrap up, but thank you very much.
I will answer really quickly. So legal assistance with proceedings are going, as Owen mentioned. If you're a lawyer, then the social sphere that you tend to mix in is different to the one that activists do. So please take our materials, spread it onto social media, talk to your friends at dinner parties. It won't gain you friends, but it might save the planet, and I reckon that's worth it. Whereas lawyers are responsible, taking a stand and said we will just not work with oil and gas companies which are committing ecocide and potentially genocide. And the final thing, cold hard cash. Make it a donation and remember to gift aid it. Thank you.
Thank you very much for that practical list, Clive, and thank you, everyone. Unfortunately, we've come to the end of the event. I'm going to invite up Harriet now, who has a few orders of business. But just, of course, first, all that's left for me to do is just to thank the amazing panelists who have joined us and offered such a breadth and depth of expertise. It's been really interesting, and I'm sure we could continue to talk for another hour, but thank you so much for coming and offering all your insights. So a round of applause, please, everyone.
Expertly chairing that panel. That was amazing. And to Carol and Tanvi for the presentation. 2025 as well for LVF. We've had a huge year, so I just wanted to, as we're wrapping up today, just thank everybody for being such loyal members and coming along to our events. We've hosted 10 knowledge sessions this year. This is the 10th. And that's only part of the story, because we've also expanded what we're offering to newsletters and blogs, webinars, community events. So thank you to everyone for engaging with that. And importantly, thank you to our stewardship committee as well. They've worked, their volunteers all do this in their free time alongside very busy legal careers. So we are so grateful to them for all of the work. I've seen how much work goes into everything over the last year. So yeah, a huge thank you to all of them as well. There's 12 of them in total. So yeah. And then I just wanted to flag as well, if you were interested in finding out more about LVF and seeing what we've got in store next year, give us a follow on LinkedIn, reshare our events. You can also find our website. We're leaving some QR codes up on the slide at the end, so keep an eye out for what's to come next year. We've already got sessions planned on legal systems change, industrial animal agriculture, and central banks on climate and nature. So already some really interesting topics, and we can't wait to hear more about those, so keep an eye out. And I just wanted to say as well that we're entirely dependent on donations. So first of all, thank you so much to everyone who has donated to LVF this year or just for this event. Every little helps, and we're so grateful, and it helps us continue to keep doing more of what we do. And do consider donating in future if you feel that way inclined. We're very grateful for however much you're able to give. So yeah, that's all from me. I will leave everyone to their evenings.
I just wanted to thank David White in absentia. Sorry, he had to run off because of a train issue. But if he's watching back this recording, thank you, David. And yes, thank you again to everyone.
And we're heading to the bar afterwards, to All Bar 1. So if anyone has any questions or wants to chat to any of the committee or just chat to each other, keep the conversation going, then please do come along. We'll be there for a little bit after this session. It's the one in Holborn, so it's just around the corner. One last thing, I've just been reminded, we have a members survey that's currently live for LVF. So if you've been coming along to our events this year, or if you're new and you've got ideas for what we could do to improve our offering, then we would love to hear from you. The link to that is in one of these QR codes potentially, or I'm not sure. But also it will be on our LinkedIn and website as well, so please do check those out. Thank you, everyone.
Thank you all very much. Great discussion. Thanks to our online audience for being such a great participative audience. Back on the juries, being a little what they're saying. I completely agree with everything you were saying. Yeah.